Did somebody from the state come and take away your children and now you're worrying about what's going to happen next? My name is Patrick Slaughter. I'm with LaFevor and Slaughter. And there's a very particular process the state has to follow on this type of case. Most likely you've been accused of what's called dependency neglect. In a dependency neglect case, there's very specific laws about how the case has to move forward. What should happen is once the children have been removed from you, you are entitled to what's called a preliminary hearing within 3 days of the children being removed. In that hearing, you go to court. You'll usually fill out an affidavit of indigency if you're having problems paying for an attorney, or if you've had the ability, you should get an attorney prior to your preliminary hearing. You definitely want to get an attorney if you can for this kind of action. But at your preliminary hearing, the judge is going to decide whether there is enough evidence or enough accusations, basically, to move the case forward to trial. It's a very low burden of proof. Typically, those are waived and reserved, which we'll talk about later. But you're entitled to a preliminary hearing. At that hearing, both sides are entitled to present evidence. And if the judge determines that there's at least some basic standard of evidence that would justify moving forward to trial, you would lose the preliminary hearing, the case move forward. Or if the judge is convinced that no, there's not enough evidence to move forward, then the case would be dismissed, you get your kids back, and that's the end of it. Most cases, however, no matter how innocent the parent is, end up moving forward from the preliminary hearing because the burden of proof is so low. One thing that also happens at that preliminary hearing is usually a judge will appoint an attorney for each parent and an attorney for the child. The attorney for the child is called a guardian ad litem, and that's an attorney that represents the child's interest. If you can't afford an attorney should be appointed to you by the state at no charge to you or at very minimal cost, like $50 or so. As I said, both parents are entitled to that. And then the case moves forward. The next step would be an adjudicatory hearing, which is a fancy way of saying a trial. And it's a full-blown trial. You call witnesses, they're cross-examined, you present evidence, and then whoever is bringing the dependency neglect case, whether it's the Tennessee Department of Children's Services or it's a private dependency neglect case being brought by the other parent, whoever brought the case has a burden to prove that their allegations that they raised at the preliminary hearing or in the complaint that was filed were met by clear and convincing evidence and that it's in the child's best interest. And then after that, if the judge does decide the children are dependent neglected, then the case would move to what's called a dispositional hearing. And a dispositional hearing is just a fancy way of saying, okay, we found that there's dependency neglect, now what are we going to do about it? Those two hearings, the adjudicatory hearing and the dispositional hearing, can both be held at the same time. They can be held on the same day or in the same event, or sometimes they're separated because sometimes a judge wants to get some feedback from some professionals like counselors or things of that sort before making a dispositional determination. So that is the process. Within 3 days, you're going to have a preliminary hearing. After that 3 days, most likely you're going to be continuing to an adjudicatory hearing, which I didn't mention, that's supposed to happen within 90 days of the preliminary hearing. A lot of times both sides will agree to have that extended, but it's supposed to happen within 90 days of the preliminary hearing. And then if the dispositional hearing isn't held at the same time as the adjudicatory hearing, it will be sometime shortly thereafter the adjudicatory hearing. So that's the process. So now you should have an idea of what to expect moving forward. Again, I would urge you, if you can, to seek counsel, to know what your rights are and have someone look over your case. I personally believe that the dependency neglect statute in Tennessee is way overbroad. Some things are obviously dependency neglect and some things ain't, but they could be in a court of law in Tennessee. So I would urge you to talk to somebody, me or any other competent attorney, but make sure you get legal advice. Don't try to do this on your own. This is not something that you're going to be able to figure out without an attorney. So, knowledge is power. Know what to expect, be prepared, and you'll be much better positioned to potentially win your case.